Now, former President Jacob Zuma is refusing to be examined by National Prosecuting Authority appointed doctors. Zuma states he's tired of the claims of ill health being treated with distrust. This comes after Judge Piet Koen in the KwaZulu-Natal High Court in Pietermaritzburg recently ordered the state may grant a medical practitioner of its choice to examine Zuma in order to assess his ability to stand trial for corruption and for that doctor to be a witness if necessary. Well, let's discuss this latest development in this matter. I'm joined by lawyer Nthabiseng Dubazana to tell us more on possible implications of this. Nthabiseng, good afternoon. Welcome to the midday view. I've seen the reports. I mean, this was a court order. Is it possible to defy it at this stage?
Well, remember this order was done per agreement of the parties. So the words of the representative for Nthabiseng Zuma and Nthabiseng was specific in his words when he agreed to this. What he said was, us as the legal representatives of Nthabiseng Zuma, we consent to the NPA having their own doctors to examine our client. However, that might be a different situation when it comes to the actual doctors themselves agreeing or disagreeing. And remember, this order was also made in absentia of the accused. So it can be assumed that the attorneys may not have had direct instructions from their client to consent to such request. So at this stage, and remember the NPA, when they made the application in terms of section 217, if I'm not mistaken, or 219 of the Criminal Procedure Act, whereby the court can make an order requesting that a sample of blood or tissue from an accused person be drawn in order for it to be tested, etc., etc. That's what they rely on when they do drunk driving cases and stuff like that. So the order wasn't in terms of the act, it was just per agreement of the parties.
Now, because of that, what we are saying, there was an agreement between the parties, but that too, from what you've reminded us, from what Advocate Mpofu said, dependent on whether Nthabiseng Zuma's, as you say, military doctors would agree or not. So if the military doctors say, we've done the examination, we as military doctors are satisfied that this is the health status of our patient, and therefore we conclude in this way, that should be acceptable.
It should be acceptable. Procedurally, that is enough. Remember, when you're an accused person and you don't appear before the court and you allege that you're sick, I, as your attorney, can just hand over the certificate that comes from the doctor that says you're unavailable from date X until date Y, or whatever the case may be. And then on date Y, if you fail to appear, then a warrant will then be finally issued against you. So what the court and the state have to just worry about is the authenticity of that doctor's note, whether or not it is fraudulent or not. To question whether or not there is a health issue and what kind it is, and if therefore that in practice, I have never seen it happen. It's just that a report is given by a medical practitioner who can be authenticated, and there can be no sign of any fraudulent activity on the report itself. The court normally accepts that situation. So this is something new that I am seeing in practice. It has never happened before where I have walked in the spaces. So it's going to be interesting to see how they're going to try and divide the accused's constitutional right to privacy, in that he has a choice on who his medical practitioner can be, who can know what his condition is, what he's suffering from, all of those things. How are we going to reconcile that these rights can be trampled upon, and what are we saying that 6 can go there? So it's going to be interesting.
Yeah, and finally, very briefly, I mean, from what you are saying, if it was per agreement, and as Advocate Mpofu said, the military doctors who've been treating the former president will then issue a report, and they'll have to agree with these NPA-appointed doctors what to do next. So he's within his right to say, no, we're fine, we have a medical report. The NPA will have a hard time in rejecting that.
Yes, they will, because now they will have to then decide if the report is false or not. Their doctor can go through the report, do research and see if such an illness even exists or whatever the case may be, and then say, okay, in my opinion, after reading this, I think this might be true or this might not be true. But then how are you going to say that the accused is not suffering from all of that if without your doctor's report, if you're not going to accept my doctor's report? So I don't know how they intend on balancing this situation out.
So in summary, the former president is well within his rights in terms of accepting to be examined by the military doctors who've been treating it, and his lawyers submitting that to the court and say, here's a proof of his state of health, and that's it.
Yes, 100%.
Thank you very much, Nthabiseng Dubazana, there for some of those insights in that story. It makes sense to me. We'll have to wait and see, though, how the NPA now will counter that position that the former president has taken regarding his health, and that report that's now been prepared by the military doctors who've been treating him. Now,